Good evening and welcome to PBS Fort Wayne. The show tonight is Life Ahead. We have this show every Wednesday night at 7:30, and every Wednesday night we change topics and we change guests so that throughout the year we're able to provide you with a lot of education and information on topics that might help you with choices you have to make in your life ahead. That's the name of the show. Now, this evening we're going to be talking with two attorneys. Not unusual for us here on Life Ahead, so this is a good opportunity for you to get some good legal advice. Jesica Thorson is with me this evening. Nice to have you back, Jesica.
Great to be back.
Specializing in elder law, and with you, Ryan Gardner. Nice to have you. You've been here many times, a number of times.
A good handful.
I should make him stand up. It's intimidating. He's like 6'5", you know, and big guy. So watch what you're doing over there, Jesica. I didn't want him that close to me here.
I'll mind my P's and Q's.
Are you specializing in elder law, or what is your specialty?
I'm more of a trial attorney.
Okay.
So the contested side of elder law, probate litigation, is really what I'm here for tonight. And but my practice goes beyond that as well.
Of course it does. And probate, by the way, is the main area we're going to be talking about here this evening. And to start us, let's have you, Jesica, explain about a will. What is a will? And what do you do with it as soon as someone dies? Where will it be, and then what do you do?
Sure. So a will is just a document that is going to provide for who should handle your final affairs, as well as where your assets and your possessions should go. So when somebody passes away, generally we start with a telephone call or some sort of meeting to just go over what a person's assets are. How are they held? Are they held in that person's name alone? Do they have a beneficiary? Is there a joint owner? For those assets that are in an individual's name alone, what we do is we have to look at the will then to determine where it goes.
Yeah.
So determining where it goes is just part of the problem. We then have to figure out the value of those assets on that particular day that that person passed. Because the value will determine whether or not we can go through an informal probate process or a formal probate process.
You said you have to figure the value of the date that person passes away.
Correct.
Even if you're not getting to it for another couple weeks.
Exactly.
Okay, why is that?
Because the value of it depends on which process will go. So in the state of Indiana, if the value of those assets is less than $100,000, we can go through an informal process.
Okay.
We do not have to have a personal representative formally appointed by the court, and we can kind of go through a shortened, simpler version. If the value of the assets are over $100,000, we have to go through the formal probate process, where we have to put a notice in the newspaper, we have to have the court designate you as the personal representative, and we have to kind of go through this particular process to administer the assets and get the funds to the heirs.
And that's where Ryan comes in. Yeah?
Well,
turning
maybe.
it over to probate. Well, what's the maybe? Whether or not you have to go to probate?
Well, whether or not all the beneficiaries agree on where those assets are going to be distributed.
Okay.
Yeah.
Always a big controversy. What would you say percentage-wise, Ryan, of clients that you've had through the years that will appeal or resist in some way?
So the term we would use is contest. They would contest a will or challenge the distribution through probate or a non-probate asset in some cases. I would say that the percentage where there's a conflict or a contest is less than 10.
That's good.
That's good, and that's a full-blown dispute, right? There's always these little squabbles that come up because, let's be honest, family disputes are not uncommon for any family, really. Yeah. And so it's those families that are usually disjointed, where you may have one child who fell out of touch for a while and then shows back up at the end to say, I don't agree with how those assets are going to be distributed.
What do you do? What's the next step for you as an attorney to do for them or with them?
Well, the first thing I do is I go to the will. We need to figure out whether or not that will, that mom or dad or whoever is leaving you something, filled it out in a valid manner, right?
Yeah.
And so in Indiana, there are a lot of finite steps to properly executing a will. usually done by a great estate planner, by Jesica. And when you have a good lawyer, you usually don't need the trial attorney in the contest, where I would usually step in, because if all the T's are crossed and the I's are dotted, that instrument usually cannot be challenged, or really should not be challenged. So,
When people challenge a will, is it a long process to get it figured out and sorted out, or does the probate judge make the decisions?
it is a long process.
Oh, is it?
It
Like
is.
what's long?
I would say at best case scenario, 6 months, but that is absolute best case scenario.
Okay.
I would say realistically 1 to 2 years would be the normal course for a will contest from start to finish. And that finish is a trial in front of a judge, or sometimes a jury even, to determine
Really?
whether or not that will is a valid instrument.
Now that's interesting to me, in front of a jury. I guess I had not heard of that before. Is that frequent or infrequent?
It is
Situation.
infrequent that a will contest would go all the way to a jury trial, but in Indiana you can request a jury to make that determination of whether or not the person who filled out the will filled it out accurately and without coercion, duress, or a lack of what's called testamentary capacity. And that's a fancy way of saying whether or not the person knew what they were doing when they did it.
These are TV show things, that you're talking about. I mean, a case where, one of the relatives contests the will, and they say, well, Mom promised me this, and, she was in sound mind that day, or that hour that she did. And how do you prove those things?
Sometimes it's not possible to prove it. Sometimes it's not possible to disprove it. And usually that's the harder thing to do, is to prove that whoever, mom, dad, your loved one, didn't have that capacity. Often we go back to the lawyer who was there, who helped prepare the document with the decedent. A lot of times we go back and we review medical records. Did they have a medical condition at that point in time that may cause their capacity to be put into question?
Would you need a doctor's written, not prescription, but written
Opinion.
Yeah.
Yeah.
That somebody has Alzheimer's or dementia, and that they may be not in sound mind to do a will?
I would say, as an attorney, and Jesica, feel free to jump in, since you're the preparer of these types of documents more than me, it's a very good practice point for an attorney who has concerns for their client before they execute a will to say, hey, why don't we reach out to your physician? I'd like to get an opinion letter from him or her to help me feel better about what we're doing here.
Yeah.
So, and really that's a nice way of saying, you seem a little confused. Let's make sure you're not. Let's go get a letter from your doctor.
Yeah.
Generally in the planning process, I'm trying to meet with an individual 2, maybe 3 times, depending on the circumstances. One is a general conversation about your family dynamics. One is it's a conversation about your assets. We're trying to just get to know you and what your family is like.
Wait a minute. Now, are you talking about the person that's the representative? Or
No,
who?
I'm talking about the person who's making
Who makes the will.
Yep.
Okay.
So in that planning process, I'm really trying to just have a conversation, because as you can imagine, some people who have Alzheimer's or dementia, they can't track a conversation for very long.
Right.
And so that initial conversation is really just for me, not only to get to know your family, but as Ryan mentioned, to see, okay, are you confused? Do you have the capacity to make this will?
Can you make that judgment?
Well, I can at least start to maybe question some things and ask for a doctor's opinion, because I am trying to accomplish maybe what they're asking me to do. And if I feel that they don't have the capacity, ethically, I can't have them sign a will.
Yeah.
And so then I have the second meeting where we actually go over the document, and I'm pointing things out in the document and confirming that this is their wishes. Again, a lot of that's just a conversation to make sure they have capacity. And if at any point during that process I am questioning that, I'm going to put a timeout on the meeting, and I'm going to say, I think we maybe need to get a little bit more information. Let's talk to our doctor. Let's make sure that we have the full capacity to sign this will, because I don't want to create a problem for his family down the road.
Well, when you make a will for somebody, somebody calls to make their appointment to come and see you, should they bring another person or not?
Generally, I don't advise it. Couples, of course, come together.
Okay.
But there are many times, especially if we're talking about some really difficult family dynamics, there are times people will bring people into a meeting with an attorney, and there are times that I'm going to say, I'm going to have these individuals step out for right now so that you and I can just have a conversation.
Yeah.
Or maybe I'll turn it into an introductory, just a kind of meet and greet, answer questions type of meeting, and then
Yeah.
I will specifically say, okay, well, when you come back, I really just need to see you.
Yeah.
And so there are lots of little ways that I can make that happen where I make sure that we're not being influenced by outside individuals.
And you have such a lovely personality and smile. I doubt that you make them angry by asking them to do certain things.
Yeah, I try not to, but sometimes obviously when you have dementia or Alzheimer's and somebody may be questioning your capacity, they can get a little agitated.
Sure.
And so you just try to find soft ways to say, well, I just want to make sure that your family is not going to be fighting when you're gone. I want to try to make this as smooth as possible for you.
Would you work, Ryan, with personal representatives in preparing your probate case, or I'm not sure the legal term
Yeah,
for
certainly.
that when you taking care of those things?
Well, the personal representative would be a party to any case.
Okay.
Whether that's with or without a contest, the personal representative is a party. But if it is a will contest, if somebody's challenging the validity of the document, the personal representative usually plays a key role in that, either purely by just running the administration of the estate, because that administration still has to go on while we're litigating the case.
Yeah.
But oftentimes the personal representative is a family member, a beneficiary themselves, and usually because they're appointed as the personal representative, they were that person's trusted advisor, confidant, someone very, very close to them. So they usually have the vast majority of the information that we really need in either defending or litigating a will contest.
Okay, all right. If you have a very complicated case, and I'm sure you've had plenty of those, again, talking about a time frame, let's say, I think this happens, I'm guessing, more frequently because people are spread apart now. And it used to be the whole family would live within 20 miles of each other, but now they're all across the country. So it might make it more difficult for the attorney to communicate with everybody in the family or everybody to make a decision. Do you find that's the case, and what do you do? How do you counsel them, or do you?
Yeah, nowadays, thanks to technology, geographic proximity isn't as big of a hurdle as it used to be.
You can FaceTime, email.
Yeah, we set up video conferences quite often,
Oh, good.
teleconferences. In person is still, I know, my preference, just because I feel like you can really get more done. You can look at the same piece of paper. You can make sure you have someone's undivided attention. I can't tell you how many times someone's been on a video conference and a small child runs in the room or a dog is barking in the background. And that's life, and that's obviously understandable, but in person is certainly preferred.
Sure.
And I think being able to read body language in a meeting sometimes, because oftentimes some of these will contests and some of these family disputes are ultimately over personal property. It's that cookie jar that's been in the family for 100 years. I remember making cookies with grandma. This was our special time together. I really want that. Well, my brother or my sister may have the exact same memory. So we're trying to argue over who still wants that. So sometimes being in the same room gives you a little bit more opportunity to solve some of those little minor things that are maybe going to manifest into something bigger over time.
Yeah.
And so if you have a couple of those meetings like that, you can kind of maybe settle some things down to where it doesn't become this full-blown contest, legal dispute.
Okay, you talked about the cookie jar. Magistrate Phil Houck has been on our show a number of times, and I love what he says as the probate judge, if you will, that a lot of times the decisions he has to make aren't over who gets the lake cottage or the existing home or the car or those major things. He may have to decide who gets the, the tea set from Niagara Falls that Grandma bought back in 1943.
Yes.
It just, again, sentimental values.
Yes.
Ryan, do these clients of yours, would they come to you with those kind of situations to iron it out before they'd have to go to court?
Yeah, that's a very common problem for most families. And I'll tell you what I try to counsel people to do is work it out with your fellow beneficiaries. Usually your siblings or
Yeah.
family members. Try to work it out. There's a lot of creative solutions we can try to come up with. I refer to it as
Compromise.
a snake draft. Flip a coin, somebody goes first, and then it's every
Rock,
other
paper,
person.
scissors.
Rock, paper, scissors. Exactly.
Yeah.
I
Well-
mean, they may be adult children, but they're children in these situations,
They
and
are.
they're fighting over
Exactly.
trinkets.
Yes.
And it is economically a poor choice to go to trial, pay multiple lawyers to fight over the cookie jars and the Cutco knife sets and things like that, because you're going to lose out on the value of it. Now, of course, there are those heirloom type items which truly are irreplaceable, which sometimes you just can't avoid the fight. And that is understandable, of course, but when it comes to the everyday household personal property items, you really need to stress to beneficiaries, we need to find a solution other than going to court, because the ultimate risk when you go to court over something like that is the judge may just decide nobody's going to get it. It will all be sold. And then everybody will get a check based upon their percentage pursuant to the
The
decedent's
judge
will.
can do that.
Certainly.
Yes.
And that, I would say that's the most common outcome when we're
Wow.
fighting over household personal property items.
I never realized that. Oh, no wonder
Yeah.
you're saying try to work it out with your siblings.
100%.
Economically, it makes sense. You could be losing relationships. I mean,
And many families do
yes,
after
many
there's a
families are
death.
completely torn apart after this. And so not only is it just from a financial standpoint, you really could be losing a relationship with not just only your sibling, but your nieces and nephews and
Yeah.
things of that nature. And so try really hard to work those things out.
And you said, and lose the relationship, you know, on down the line. And that carries even into the next generation. Well, my mom had one sister who, you know, hid this or that, or you
Yes.
know, not good, not
Yep.
good. Okay, let's talk about beneficiaries a little bit. We obviously have addressed that here on Life Ahead, as we've talked about making a will and protecting your assets. Jessica, you're
Yes.
the attorney here, so you take this question. Let's say somebody's passed away. You have the paperwork, you have the will, and you know, a list of their assets, and so you have a list that says, okay, Susie is supposed to get the proceeds from this IRA, but all of a sudden, Matt, a second cousin, steps in and said, no, she promised me that when we had lunch together a couple months ago. What do you do?
So really we look at the documents. So oftentimes IRAs, annuities, life insurance, those things have beneficiaries, which are actually things that are going to go outside of the will. So when I'm counseling clients about their estate planning, I'm not only looking at the assets that could flow through the will, but the assets that are going to be going through beneficiary designations. This is where most people are going to choose to have all of that match. They want everything at the end of the day to go to the same individuals. They're just going to happen through different mechanisms.
Yeah.
But every once in a while, we will have some people say, I really want this pot of money that has a beneficiary on it to go to this person in honor of all what they did for me during my life. They took care of me when I was sick and whatever other reasons it was for.
Yeah.
Well, that beneficiary designation, because it's like a contract with the company that you have that account at, that beneficiary designation holds. So
And
at the end of the day,
it trumps the will. Yes?
yeah, sort of, in the sense that that is going to be governed by that beneficiary designation, and the will is, it just doesn't matter in regards to that particular account.
Okay. Do people understand this, or do they think that if she told me this, that I was a beneficiary, or it was in the will, that I should get it regardless?
Unfortunately, that does happen. We've had cases where throughout somebody's lifetime they have said, oh, this bucket's going to go to you. This life insurance is, it's just, they've said it over and over again. Either they didn't do their own diligence to confirm beneficiaries were correct, or maybe they were just telling them a lie. That does happen, and it is unfortunate, but at the end of the day, what's on those documents is what is going to control.
Okay, let's go back to probate. That's exhausting to think about. But this is like a part of the things that you're going to have to face, or your parents or neighbors or whatever. So you often find yourselves in conversations about this topic. Let's go back to you, Ryan. Probate. Tell me a couple of the things that are typical that you have to deal with. Typical situations.
Typical situations. As far as contests, at the very beginning, sometimes there's a fight over who is going to be the personal representative. Who will be that person who's going to...
If they haven't been named by the person who passed away?
Sometimes even if there's a named personal representative. In Indiana, the law says that the court can even go against a will and appoint the best suited person, basically.
Yeah.
And the named person is not always the best suited person. So that's sometimes a common fight. Probably not that common, but it comes up. Other than that, the day-to-day administration usually is not a huge issue. It's that fight over the stuff.
The stuff.
The stuff. That's what everybody wants, the best or the most. That's the most common issue when we're dealing with probate contest issues, in my opinion.
Yeah. Are you agreeing with that? Does that come to you, or is that something that passes on to a probate attorney?
So generally it will start with me oftentimes, because I will be talking with somebody immediately after they pass. Generally speaking, people will call as soon as somebody passed, within days. And then we kind of work through some of the funeral issues, and then we start talking about the will and the assets and how to proceed from there. And so in those couple initial meetings, we are really chatting about the family and some of the issues that came up, because a lot of issues come up at the funeral. High emotions, people haven't seen each other in a long time, people are wondering what's happening to the house and the stuff in the house, and so lots of different grief. And so in those initial conversations, I'm kind of feeling out what maybe the issues are. And sometimes I can see that the writing on the wall, so to speak, that there's going to be a dispute here. And so that's when I kind of alert Ryan to say, okay, I think this family may be going towards some fighting. Here's the background, here's the history.
You take care of it, Ryan.
Well, a little bit. I try to get, as Ryan says, we try really, really hard to counsel clients to work it out and to really give it some space, give it some time. These things really don't have to be done within a month of somebody passing, or even 3 months after somebody passes. You really can slow things down, let some of the emotions pass, and then deal with it. And so we really try to counsel all of that, but there are times when I can just see that we're going down that road, and there are certain time frames that we do have to follow in an estate, and so we got to make sure that we're at least keeping things somewhat moving.
Okay, tough job that they have, certainly. And I think probably it's typical that people get impatient. They think, Grandpa died 3 months ago. Where's my money, or where's my stuff? Shouldn't this be settled by now? Doesn't happen, does it, Ryan?
It happens in a lot of cases, and sometimes they race to the courthouse. Going back to that fight over being the personal representative, some people want to race to file their petition first, to ask the court to be appointed first, and the court usually doesn't know anything about that family, that situation. Is there a will? Is there not a will? They're dependent upon the information provided to them. And so someone who doesn't have a copy of the will may not know better, or may not want the court to know what the will says. And then they petition to become the personal representative because they want that immediate power, because of those immediate conflicts over what are we doing with the house and the stuff in it.
What do you do if down the line there's a dispute? Maybe a relative, there's a personal representative that's been handling everything with the attorneys and maybe selling assets and kind of getting everything cleaned up. But then one member of the family comes up and says, they did stuff wrong. They aren't being honest. I don't trust them. What do you do, Ryan?
Well, a personal representative is supposed to be providing information to the beneficiaries throughout the administration of the estate. Some estates are what is called supervised, and that supervision is by the court, which really means you can't do anything as personal representative without the court's permission.
Okay.
You can't sell assets. Now, you can handle the day-to-day paying bills and things like that without the judge's okay. But when it comes to selling assets or making distributions, you have to have a court order before you do that. even in an unsupervised estate, a personal representative still has obligations to provide notice to the beneficiaries and ultimately then provide the court a final statement or accounting of, well, this is how I've distributed all of the stuff. And it's at that point in time where a beneficiary or an interested party can step in and say, no, 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 that's not right.
Yeah.
And you don't always have to wait till the end. You can definitely do it before then. But usually that final accounting, that's the notice and the trigger for if anyone has an objection to this, you better speak up now. If not, the judge may eventually then okay that distribution because, again, the court only knows as much information as is provided to it.
Yeah.
So if nobody contests it or objects to it, the judge may not think there's anything wrong with what that personal representative
And then
has
you have
done.
to leave saying, well, we didn't do our jobs, but the judge spoke and that's it. Thank you for coming and for sharing your information and education. I hope you learned something. I certainly did here. And it's a very complicated issue, taking care of any probate cases or winding up a will situation. Meanwhile, we'll see you next Wednesday night right here at Life Ahead on PBS Fort Wayne. Good night.
The preceding program on PBS Fort Wayne was made possible in part by
Beers Mallers, elder law attorneys, providing information on legal matters of guardianship and financial issues relating to nursing home care. Beers Mallers attorneys can also assist with Medicaid requirements and help navigate difficult family situations. Beers Mallers, attorneys at law, with offices in Fort Wayne, LaGrange, and on the web at beersmallers.com.